Okay, good evening, everyone, and welcome to the Hillsborough Township Planning Board meeting of March 7th, 2024. Please join me in a salute to the flag.
Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Please be advised this meeting has been duly advertised according to Section 5 of the Open Publics Meeting Act, Chapter 231, Public Law 1975, otherwise known as Sunshine Law. Notice of the 2024 annual meeting schedule has been provided to the officially designated newspapers, the Township Clerk, posted on the Township's website, and available here at the Hillsborough Township Municipal Complex. In addition, application documents and plans have been made available on the Township Civic Clerk website at least 10 days in advance of this evening's meeting. Complete application files are available in the Planning and Zoning Department for inspection in accordance with the public meeting notice. And with that, we have to do a couple of votes before we go to roll call, correct?
Gentlemen,
So, Mr. Radowitz, who's moving from alternate seat number 1 to seat 7, and Angela Vitale, who's taking Mr. Radowitz's place as alternate number 1.
Gentlemen, raise your right hands, please. I state your name.
I, Bruce Radowitz,
Do solemnly swear
do solemnly swear
that I will support the Constitution of the United States
that I will support the Constitution of the United
and the
States
Constitution of the State of New Jersey,
and the Constitution of the State of New Jersey,
that I will bear true faith and allegiance
that I will bear true faith and allegiance
to the same
to the same
and to the governments established
and to the governments established
in the United States
in the United States
and in this state
and in this state
under the authority of the people,
under the authority of the people,
and that I will faithfully,
and that I will faithfully,
impartially,
impartially,
and justly perform
and justly perform
all the duties
all the duties
of the office of
Class 4 member
number 1 of the Planning Board
of the Planning Board
to the best of my ability,
to the best of my ability.
so help me God.
So help me God.
You're now
All
stuck.
right.
I will attest. I think you know the routine, just fill them in, we'll attest.
Pass it down.
Pass it down,
Oh, pass it down.
pass it down. Okay.
Like fourth grade.
Yeah.
Ask me if he wants my driver's
Teacher will have to mark it.
Okay.
Sean?
So with that, may I have a roll call of planning board members and board and township professionals, please?
Mr. Wagner.
Here.
Mr. Radowitz.
Here.
Mr. Scobo.
Here.
Ms. Smith.
Here.
Mr. Vitale.
Here.
Did I say it right?
Yes.
Mr. Deb.
Here.
Committeeman Lapani.
Present.
Deputy Mayor Ciccarelli.
Here.
Vice Chair Deason.
7.
Chair Sirachi.
Here.
Mr. Coyce.
Present.
Mr. Bernstein.
I think I'm here.
Mr. Mayhew.
Here.
And myself and the videographer are here.
Okay, welcome, everyone. We do not have any meeting minutes for consideration. However, we do have a resolution for consideration. Hillsborough Center LLC with file number of 23-PB-14-SP. May I have a motion to approve?
So moved. Second.
Okay, any discussion from the dais? Hearing none, roll call, please.
Mr. Wagner.
Yes.
Mr. Radowitz.
Yes.
Ms. Smith.
Yes.
Mr. Deb.
Yes.
Committeeman Lapani.
Yes.
Deputy Mayor Ciccarelli.
Yes.
Vice Chair Peason.
Yes.
Chair Sirachi.
Yes. Moving on to planning board business. So just because Mr. Radowitz just took seat number 7, that was due to Mr. Frank Delcourt, former committeeman and mayor and longtime colleague up here on the planning board. Had resigned his seat last month. So I just wanted to formally thank Frank for all the years that he put in here. He's going to be missed up here. Hopefully he'll come in and just visit us and hang out for old time's sake. So
You're nuts.
I'm an optimist.
Yes, thank you, Mr. Delcourt, for all you've done, 100%.
Okay, next business item, 303 ML Road, JMJ4, Abil Inc., file number 21-PB-17-MSPV. Looks like we have to schedule. They do have a time of decision till June 1st of this year. Mr. Coyce?
I have nothing to report on this one.
Okay, there's this.
Are they scheduled, Mr. Coyce, right now?
I do not have.
Mr. Chairman, I would recommend that the board pass a motion scheduling 303 Amwell Road JMJ for ABL Inc. for May 9th at 7 p.m. or soon thereafter, as the matter may be heard without further notice.
May I have that motion?
So moved. Second.
Okay.
I
Do we
would
need-
point out, Mr. Chairman, that the eligible members are Mr. Wagner, Mr. Radowitz, Mr. Scobo, Ms. Smith, Committeeman Lapani, Vice Chairman Peason, and yourself.
Thank you. Any comments? Roll call, please.
Mr. Wagner.
Yes.
Mr. Radowitz. Yes. Mr. Scobo.
Yes.
Ms. Smith.
Yes.
Committeeman Lapani.
Yes.
Vice Chair Peason.
Yes.
Chair Sirachi.
Yes. Okay, we do not have considerations of ordinances, so we will now move to business from the floor for matters not on this evening's agenda. If you would like to provide any commentary, please state your name and name and address for the record, and also please refrain from any comments regarding warehouses directly or indirectly.
Thank you. Greg Colmer, Taylor Avenue. I'm just going to read out, apologize, I like to look at people, but I'm going to stick to the script here. So first of all, I just want to thank the board for their time, dedicating as a volunteer, and one that is electing to represent our town and listen to the public. Thank you very much. Second, just want to acknowledge the efforts that you make for the public to question witnesses, engage in discourse with applications that come forward. So my comment, or maybe concern, or whatever, maybe in a minute, just maybe a little nitpicky, but it's more of a question of understanding process. Unfortunately, I wasn't able to attend last month's meeting, or the last meeting, but I did watch the recording, and my comment is in reference to application 23-PB-14-SP. After watching the recording, I again want to thank the board for offering the opportunity for the public to question the engineer after their testimony. However, absent from the overall process was the opportunity for the public to speak for, against, or make a comment on the overall applications itself for the board to hear prior to voting. It is not the first time I've spoken about this. I made a comment during this forum about, I don't know, a year and a half ago or something. In that case, Chairman, your response was to the effect, well, it was a simple lot line adjustment, and those are for the board, and confirmed with Mr. Bernstein whether the board needed to open for public comment on such a simple, and those are my words, application. I expressed, though, concern that the public comment may not be open for other applications. You assured the public at the time that the public would have their time at another bite of the apple, sorry to use some words that you hear, for other applications that are opening or ongoing. However, the same thing just happened. There was no opportunity for the public to be heard. I noted, I didn't want to be nitpicky here, but the concern is this, and I, perhaps other members of the public, are confused, though, when we are allowed, able to make a comment about a particular application. So during this period right now, you have set a rule that no comments can be made during or towards an open application to protect the record, which I understand. During witness public comment, you rightfully so ensure comments are directed towards the witnesses and not towards the board, and thank you very much. However, if there's no such opportunity at the end of the application when a motion is made to affirm or deny, then there's no such opportunity for the public to make comment on the application itself. Again, the intent's not just to understand the process here and to ensure that's consistent in order to have predictability or reliability to make a comment. So if the public cannot make a comment for open applications during this portion of the meeting, then there's no problem. No problem. Then one needs to be provided for after a motion is filed for all applications. If no such opportunity will be provided, then I believe the public has a right to clearly understand when such comments can be made. Again, I want to thank your time, and I'll leave it at that.
I will admit I don't recall whether or not we denied the public the opportunity to speak on the application at the end. But for purposes, and I will use this application for the sheer example and nothing more, Mr. Giannetti and objectors. Mr. Giannetti will at some point come up and continue his application and his examination of witnesses. At some point, he will conclude his direct presentation. Following that will be the objectors and any of their witnesses. Following their presentations at that point, assuming nobody is coming back for rebuttal, that will be the point in time, for example, with this application, that the public will be allowed to speak on any aspect of the application prior to any action being taken by the board, which is what the board has done all along in every other application. I realize it has been a while, and possibly longer than some of us can remember, the last time we got to that point in an application, because almost all of our applications have been double-digit hearings that have not yet found its way, but when that time comes, that's when the parties will be allowed outside of the objectors and the applicant in this case to make comments and state their opinions relative to this application per se.
Thank you. Any other comments from the public?
Maria Janusik, 720 East Freck Avenue, Manville, New Jersey. I'm also a Hillsborough Township property owner, Block 86, Lot 3, 2155 Camp Lane Road. Could you please tell me, in accordance with the municipal land use law, what is the obligation of an applicant towards property owners within 200 feet of the subject property of the applicant?
Notice.
Excuse me?
They need to notice.
What kind of notice?
Written notice of the application, that's it. Notice of dates, hearings, that's it.
And that has to be sent how?
It has to be sent out to property owners within 200 feet in accordance with a list provided to the applicant, usually from the tax assessor's office, as generated by, and correct me if I'm wrong, David, Mod 4, which is a program created by the state for such. The applicant relies upon such and sends out the notice. That doesn't always mean that everybody who should be in that list is necessarily on that list, and they are required to advise the board that they have sent out the notice to the public. The green cards are not required to be sent back. The only notice that's required is that notices have been sent to the following individuals on the 200-foot list.
But that has to be sent via certified mail with a return receipt.
Not necessarily.
It does not have to be sent via certified mail?
It does not have to be sent by certified mail. It can be, and it's not required for the green cards to prove delivery to be turned back.
That's not required?
No, it's not required the green cards be turned back.
Okay, so there's no requirement of the green card at all because you're not sending it certified mail?
There is notification that the individual has been provided, but the state law does not require that the green cards be sent back.
You keep saying it doesn't have to be sent back. If there's no certified mail, then there is no green card at all, never mind
That's
talking
correct,
about sending it back.
but almost every applicant sends it out certified and usually mail, sometimes also regular, to ensure that they have in fact have a record that they send out the documents to the people within 200 feet.
Okay, because there is an application that was put before this board that is within 200 feet of my property, and I did not receive notice, but I'm seeing here that the applicant is going to provide re-notice. How can you provide re-notice if there was never an initial notice sent out? And in regard to that application, which is
Mr. Coyce, that's your
Sherman
right.
Tract, There are two documents that are mentioned in the application, but yet they were not provided as part of the documents that are submitted for the public to read and to be able to question, and that is the settlement agreement and the Sherman redevelopment plan. Those were not provided, those documents were not provided for that application. My other question is, what is the law regarding properties that are the subject of an application before the planning board that are currently not conforming, that they are not permitted in that zone, and they do not have a certificate of non-conformity? How is that property treated?
That's not an issue for this board. That's an issue for either the planning and zoning department and/or construction and/or engineering or the township itself, but it's not a board jurisdiction issue.
We were informed by the applicant that they were not going to be here this evening, and this is what they indicated. The applicant will be sending out new notices to the property owners within 200 feet of the subject property and will republish the notice of the new date in the newspaper as well. And so we have them for April 11th, tentatively. They, of course, have to notice and meet all those requirements in order to do so. So meeting anyone that's within the 200 feet, need to be noticed, and they need to be noticed sufficiently in the newspaper as well.
I understand all that, but I'm saying what I read was that they're going to send new notices when there were originally no notices sent out.
All I could say is we did not receive any copy of any notices that they would have sent, which makes us think that they didn't put a notice out. Normally what happens is we receive a copy of the notice, but the applicant didn't provide that. They provided a letter stating that they would like to be heard at a different date.
And does the planning board have a copy of all of the properties that are within 200 feet?
It's within the application. So an applicant receives a list of all the properties within 200 feet from the planning and zoning department. So it's within the department. It's not necessarily something that the planning board members are looking at individually. It's something administratively that the staff is looking at.
So
Okay.
we're looking at the list on Sherman Tract, and your house, your name is on the list.
The what?
Your name is on the list in Civic Clerk
So-
as being noticed, or as provided by the township to be noticed.
Not noticed, but to be noticed.
You are on the list, though.
Okay.
And your address and Freck Road is the address listed to send it
Freck
to.
Avenue, not Road.
Freck Avenue, yep.
And what I want to specify is that the applicant is claiming to be giving renotice when there was originally no notice given. And my second question
Well,
had been...
Ms. Janicek, to be fair, you didn't receive the notice. They noticed, and they're just saying that sometimes when they have an application that is moved, renotice is not required. They are saying they are going to renotice when they have the date.
So you're saying that other property owners did receive notice?
You're the only one here saying they didn't.
I'm the only one saying I didn't.
That's
Okay.
present.
I'm going to request a copy of that list.
It's on Civic Clerk.
My other question...
Ms. Janicek, it's on Civic Clerk. You can look at it yourself. It's on Civic Clerk.
What's on Civic Clerk?
The list that you're asking for.
I didn't see it.
It's right there. He's looking at it right now.
Okay, all right, because I didn't see it. My other question had been in regard to properties that are the subject of an application that are currently non-conforming and don't have a certificate of non-conformity. How is that? How is that dealt with?
I'm not going to answer a question in the abstract, ma'am. If you got an allegation as to a specific property and a specific application, put it on the record and we'll look at it. But otherwise, I'm not going to engage in an abstract.
Okay, so the two properties from Homestead Road, I believe one is a residential use and one is a farm use, and those are not permitted uses in that zone.
Current are not permitted in that zone.
Excuse me?
Current uses are not permitted in that zone? You just rattled off two properties. I'm assuming that tonight's application,
Yes.
Which we're not
which
discussing.
we're not discussing, but more importantly, your contention is that one is currently being used for farming, and one is currently a residential. And your contention is that neither one of them is a permitted use in their current
The
situation.
current zone, yes.
Okay. We'll look into that part. What it has to do with this application is immaterial to what they're currently being used for.
I would
Okay,
think,
but if it's a non-conforming use, it should have a certificate of non-conformity, otherwise it's not in compliance with the zoning ordinance.
It's not required necessarily to have a certificate of nonconformity.
Why? Why is it not required?
I'm
It's
not
the
going to
first
get,
time
I'm not,
I'm
ma'am, I'm
sorry,
not
it's
going
the
to get
first
into
time
that
I'm hearing that
discussion.
because I had been told something other in regard to my property. Thank you.
Thank
You're
you.
welcome.
Any other members from the public? Okay. Seeing none, we're moving to this evening's applications. First up, I guess with regards to the Sherman track, are there any representatives here, or are we just going to read through?
No representative are aware of, Mr. Chairman. They have indicated that they asked for an adjournment from the planning department, which was then apparently granted, and they have indicated they will be renoticing all the parties, whether or not they noticed or not. I will point out that renotice is a term of art. They may not have noticed, but if they had not noticed, they are still required now to renotice. So in order to conform, and that apparently with the board's approval is to April 11th at 7 p.m. as soon as the matter may be heard. And they'll be the first ones up on the agenda.
Okay.
So we need a motion to do so.
Is there a motion to adjourn the Sherman Track Phase 2, M&M at Camplain Road LLC with file number 23-PB-18-MSP, time of decision of May 17th of this year, to adjourn till the April 11th, 2024 Planning Board meeting at 7 p.m. or soon after the meeting starts, with notice of an April 11th meeting.
Mr. Chairman, I'll move. So moved.
Second.
Okay. Any comments? Roll call, please.
Mr. Wagner?
Yes.
Mr. Radowitz?
Yes.
Mr. Scobo?
Yes.
Ms. Smith?
Yes.
Mr. Vitale? Committeeman Lapani?
yes.
Deputy Mayor Ciccarelli?
Yes.
Vice Chair Peason?
Yes.
Mayor Sarachi?
Yes.
Thank you, Mr. Chairman.
No, thank you. So
And-
now,
Mr. Chairman, before you begin on the next matter, I will continue my recusal on that matter and wish everyone a good night.
okay,
Let the record reflect,
that's it.
Mr.
I know.
Radowitz gets his promoted seat, is now recusing himself as he has prior hearings on this application and has left the dais.
All right, good evening. Okay, we have Homestead Road LLC, file number 21-PB-25-MS/MSPV, time of decision, April 1st of this year. This is continuation from our January 25th meeting of this year without further notice. I'm just going to ask everyone to introduce themselves again.
Sure, yes. Good evening, Chairman, members of the board. Craig Genetti, the law firm Dave Pitney, on behalf of the applicant Homestead Road LLC.
Good evening, Mike Pissarro, Policy Director for the Watershed Institute. You're green.
Suzanne Oxy, I'm representing SWAT. I'm an official member of SWAT, and I'm here on behalf of Brian Tarantino.
Scott Bruce.
Objector number 2.
Lucy Sandler, objector number 5, representing the Sauerland Conservancy.
John Lanahan. Hold it. John Lanahan, chapter number 4.
All right, welcome, everyone.
I'm sorry, could I get Susan's last name again? Your last name?
O-C-H-S, like in Sam, E.
And just to clarify, you're saying you're now a member of SWAT?
I've one of the original members.
You were one of the original members?
Yeah. There's documentation submitted to the planning board some time ago.
And you previously questioned witnesses before?
Pardon me?
Have you previously questioned witnesses before?
Have I ever?
On this application? Question, okay.
Brian has always been here. It's my understanding that since Brian represents me, that I am not permitted to speak. Is that correct?
You're not permitted to question the witnesses other than in your capacity as a member of SWAT. So you are now, at least for this evening, because I believe the board and everyone is aware Mr. Tarantino advised everyone he would not be present tonight, that Ms. Oxley is basically here in Mr. Tarantino's stead and will be allowed to ask questions in a capacity as an objector, but otherwise you will not be allowed to ask questions normally from the audience. You are simply...
Wait, do I have to have a note from Brian that it's okay?
No.
Okay, great.
I think we'll accept it, and I believe you are.
Okay, Counselor Floor.
Sure. Good evening. Again, Chairman, members of the board, Craig Genetti, the law firm Dave Pitney, on behalf of the applicant Homestead Road LLC. This is a continued application for preliminary final major site plan approval and minor subdivision approval for a property located at 189 and 203 Homestead Road, property located in the TECD Transition Economic Development District, where the applicant is proposing to construct 2 warehouses on the property. We presented a slew of testimony so far. At the last meeting, we had our environmental wetlands expert, Mr. Cook, testify. There was some discussion as to what was in his report, what he could testify to, so on and so forth. We obviously made the argument he's not, everything he's testified to was in a report that has been submitted, whether it's regard to his environmental impact statement, with regard to his prior letter to the board and or the DEP applications. Notwithstanding, since the last meeting, we did have him prepare and submit a supplement report to his ERI, the Ecological Resource Inventory and Impact Assessment Report. Based on that, since we were not permitted to go down a certain avenue at the last meeting, I have a couple follow-up questions for him, and then we can open it up to questioning from the public and cross-examination from the objectors and then the public as well.
Okay.
If I may just ask a point of order. At the end of the last meeting, Mr. Cook's direct testimony was ended, and twice on the record, Mr. Giannetti was asked whether there was any intention to supplement Mr. Cook's report. In both questions, the answer was no. So, given that the applicant rested their direct and indicated no supplemental report was coming, should that be allowed? And I can give cites to that transcript if necessary.
This is our application, and we're permitted to present whatever evidence we want. We were precluded from going down certain paths that they said was outside the scope of reports. At the time, we felt we had enough, but then we decided afterwards that we want to supplement the report so the record's clear and ask them the questions we wanted to ask at the last meeting. I don't see why the board should preclude us.
Okay. And Mr. Courts, we received this at least 10 days before this evening?
I could double check, Mr. Chairman.
I'll submit it was submitted more than 10 days before the meeting.
Do you recall the name of the report?
It's called Ecological Resource Inventory and Impact. It's the same
You have it?
report, just it says supplement report.
February 23rd.
There was the date of the
It's
report.
dated February 23rd. Is that enough, Mr. Chairman? You'd like me to verify? Okay.
And Mr. Chairman, just to continue for the record, issues were made during applicant's witness about giving testimony outside the scope of his original report. Mr. Giannetti had issues with it. I'm characterizing it that way. And apparently decided, my words, to see the light and submit an amended report and seek additional questioning. So I believe this report is in response to the board's requests, and I believe, correct me if I'm wrong, Mr. Giannetti, also respect to Mr. Mayu reports.
I'm sorry, with that last part?
Mr. Mayu's latest report, this is also in or not?
Mr. Mayhew, what do you mean? Is it?
Was it in response?
Whether this,
Oh, in part, yes.
Thank
In
you.
part, yes.
he's going to
We're good.
testify,
We'll
have him
allow
sworn in.
Yeah, swear back in.
You swear any testimony you give tonight's the whole truth and nothing but the truth?
I do.
Let the record state plainly.
Sure. First name Edward, last name Cook, spelled K-U-C. Thank you.
So, Mr. Cook, at the last meeting, you presented various testimony concerning the wetlands and stream corridor on the property, as well as your kind of investigations and evaluation of the property. In that evaluation of the property, did you find any areas that you would consider as critical ecological significance?
Yes, I did. First and foremost, there were areas that, based upon my field evaluations of the property, looking to see what areas on that property would be considered to have significant ecological values. First and foremost, the main tributary of Royce Brook. That corridor that runs along the northern portion of the property, that, in my opinion, would certainly be considered as having a critical ecological resource associated with it. Also, what I identified, even though they are narrow and small and so on and so forth, the tributaries that run down through the property. They are a water resource. They are contiguous. They are naturally occurring. Therefore, I consider those in my evaluation to have a significant ecological importance. Also on the property, there's an area in the northeastern central region of the property that is actually rather free of alien invasive species. It's an area that comes about with a mid-sectional field, the tributaries, and so on and so forth. Based upon the distribution of the habitats and the availability of habitat there, I considered that portion of the property also, even though not regulated, to be considered as an area of ecological importance.
And aside from regulatory compliance issues, what was your recommendations to the project from an ecological perspective?
Well, first of all, again, in addition, first questions asked of me were from a regulatory compliance standpoint, but of course, having to give opinions, from a Bugs and Bunnies standpoint, my recommendations, obviously, for the overall project were, number one, to the greatest extent possible, protect that Royce Brook tributary corridor. DEP required a 50-foot wetland buffer associated with it. The FHA verification required a 50-foot riparian zone. Again, like I said, because of its resource value, its ecological resource value, I wanted to see and made the strong recommendation that to the greatest extent possible, any disturbance of that area be avoided and the greatest buffer to that be incorporated. Also, my recommendations were to protect those smaller tributaries. Even though they are small, they are narrow. My recommendation was, to the greatest extent possible, to avoid disturbance to them and increase the buffer zone to them to the greatest extent that they could. The other important thing that I wanted on this particular property, that my recommendation was to utilize existing disturbed areas to the greatest extent possible. Any presently developed areas, any presently disturbed areas or manipulated areas, I would want to see those areas be developed first and incorporated into the into the overall development plan before we went extending out into the more natural areas. The other thing that I wanted on the project site was, to the greatest extent possible, to try to incorporate contiguous habitat post-project. And what I mean by that is to try to, with when you're developing something and you're redeveloping on an existing developed area, given the characteristics of the site and the size of the site, my recommendation was, if there was going to be multiple buildings on it, that the layout of those buildings be such that we could still preserve and maintain a large as possible contiguous area and contiguous habitat, preferably even connected into the Royce Brook habitat, so that we would have one big main corridor associated with it. Finally, one of my strong recommendations to the project was to maintain and even create grassland bird habitat. That's what we're lacking in the area, and unfortunately for grassland bird habitat, natural succession unfortunately renders an area unsuitable for grassland birds. So, given the opportunity, my recommendation to the project was to maintain grassland habitat, actually improve it and then maintain it.
And has the applicant incorporated those recommendations you just discussed in this project?
Generally, yes. It was pleasure to have someone listen to the Bugs and Bunnies guy. First of all, with regard to the Royce Brook stream corridor, or the main tributary to Royce Brook, the project incorporated increased buffer zones. They included the buffer associated with it from a stream corridor ordinance in Hillsborough, which is great. They increased it to the greatest extent possible, minimized the stormwater outfall structures associated with it, and therefore minimizing the impact to that, and incorporated the greatest buffer that we could to that particular area. Building number one, the larger building, if I'm calling that correctly, between 1 and 2. When I referred to building number one, I'm talking about the large one that's right along Homestead Road. The placement of that building was all the way to the east. That already incorporated existing developed area, and minimized new habitat disturbance, and utilized what was already developed and already disturbed to the greatest extent possible. With regard to building number two, again, it was nice that they listened to me on this particular thing. My recommendation was, when I was just talking about creating a habitat corridor or maintaining a habitat corridor. So in order to do that, the recommended placement of a second building, if there was going to be a second building, was to be as far to the northwest as possible, so that we could keep that large contiguous habitat area in the middle of the property, and therefore have a continuum between that and that Royce Brook tributary. That they incorporated. Also, as far as building number two goes, building number one's right along the road, an already developed area. Building number two, my recommendation was to keep it as close to already disturbed areas as possible, meaning the Route 206 bypass and the railroad tracks. So that's why that second building is tucked up as close to there as possible, thereby offering the availability of that large habitat corridor that I wanted through the middle of the property. My recommendation was that the access road to that second building, to incorporate the existing crossing to the tributary, rather than making a new crossing. That means they had to adjust the road a little bit here or there, but I would rather use an existing crossing or existing disturbed area rather than making a new one. My recommendation was only to have one crossing, but I was overruled. I believe I was overruled by the township on that particular thing from a safety standpoint. So they ended up having two crossings of that tributary stream. But again, with regard to that, those crossings are made in the most perpendicular manner as possible, thereby minimizing the encroachment into that resource and minimizing encroachment into the overall corridor that we want them to keep. Finally, one of my best recommendation to the thing was that this particular project dealt with stormwater outfall structures that required permitting through the DEP, which thereby triggered DEP's stormwater review. You guys are probably quite familiar with the fact, and we take great, very good pride in this, that New Jersey has the strictest stormwater management regs when it comes to flood control and water quality in the country. That's something that's that a lot of people will complain about. A lot of engineers will complain about because it's tough to deal with that. But that's what the project has to do. So what this project has to do is, and had to, comply with the strictest stormwater management regulations, and that was approved by the DEP.
Now, going back, excuse me, you testified at the last meeting on the town stream corridor ordinance. In your review of that, what is the purpose of the ordinance?
The stream corridor ordinance that Hillsborough has is great. I like it. I think it was originated by Peg Van Patten. Worked with her a lot. Used to be the president of the, or head of the Environmental Commission. She was very influential in that. The Township Stream Corridor Ordinance is very beneficial when we have a resource, and we have a water resource, we have a natural water resource. What it does, it serves to give an added protection to that water resource. And as a supplement to that, and as a secondary benefit to that, what it does is it preserves habitat associated with it. So whether or not that actual 150 feet adjacent to it is really serving to keep water temperatures down or keep sedimentation down or so on and so forth. Even if it does none of that, what it does do is it provides protected habitat and protected corridor that, of course, is, any corridor that can be utilized for wildlife and so on and so forth is certainly beneficial.
So I guess back to your testimony in connection with the ditch on Lot 33, if the township imposed the stream corridor ordinance and that buffer on this ditch, what would that mean?
Just to confirm, we're talking about the ditch that we had a lot of discussion about on Lot 33, correct?
Correct.
Okay. As I said before in my last testimony, this ditch, this man-made ditch, was there and created for the main purpose to convey stormwater from an impervious surface that's utilized as a vehicle parking lot and an equipment storage area to convey runoff waters
I'm going to
from
have to
that.
object. He's testifying to facts and actually we went through this last time. There's no evidence, there's no expert opinion of why this was built, if it was built, and when.
He provided at the last meeting how he got that information, and he was allowed to testify at the last meeting. He can continue with this answering.
There was a huge discussion with Mr. Bernstein about hearsay. So
there was a huge discussion, but he testified to it.
Please note my objection.
You can cross-examine him all you want.
I certainly will. But
There's a variety of different graded inlets throughout the impervious parking area and storage area that all discharge into one pipe. That pipe, at the discharge of the pipe, is the origin of this ditch. This ditch then goes in a very linear, narrow fashion directly into Royce Brook. This ditch has no water quality capabilities, no flood control capabilities. It wasn't made for that. It was made to convey stormwaters, obviously. If the stream corridor ordinance, and just backtracking, at present, waters from impervious surfaces that are holding vehicles are going into this, being discharged into this ditch, and this ditch is discharging directly into the stream corridor associated with Royce Brook. If the stream corridor ordinance was imposed on this particular ditch, it would require the preservation of this ditch and the preservation of 150 feet around this ditch. Now, at present, the area around this ditch is entirely maintained, consists of impervious parking area, buildings, lawn, a house, and solar panels. That's what would be preserved.
From an ecological perspective, do you consider this ditch to be a point of source of degradation to Royce Brook?
That I do, yes. The reason for that is because it is discharging untreated stormwaters directly into an area that I consider having a critical ecological resource.
And do you consider this ditch in 150 feet area surrounding it as a separate and distinct natural habitat?
No, I don't. And in my evaluation and mapping of habitats on the property, this was all considered, I considered all of this under the developed criteria, meaning something that is presently manipulated and has minimal, if any, ecological value.
So, in your opinion, if the ditch and the 150-foot surrounding area were considered as a protected stream corridor by the township, this would preserve the ditch that serves as a point of source of degradation to Royce Brook along the adjacent lands that are already developed and disturbed, which could continue to contribute, or in your opinion, would that continue to contribute to the degradation of the Royce Brook? I know that was a long question.
Yeah, that was a good question. My God. And, yes. Okay. Let me backtrack. Let me answer that by rewording the question, if I can. Yes, if that ditch and if a stream corridor of 150 feet around that ditch were protected, what would be protected would be a continuum of a point source of degradation to the main tributary of Royce Brook, because it's conveying untreated stormwaters from impervious surfaces directly into Royce Brook with no treatment. Did that answer your question?
Yes, it does. Now, does the proposed project include the preservation and the continued use of this ditch?
It does not. The proposed project incorporates disturbance to a large portion of this ditch. This ditch is not going to be utilized by the project as a stormwater conveyance or even a stormwater outfall.
In fact, as testified at the last meeting, as an ordinary resource value wetland with a 0-foot buffer, we've applied for a wetlands general permit to fill the ditch, correct?
That's correct. There is this freshwater wetlands general permit number 7 that is pending, that is for the authorization to disturb the ditch as proposed.
In addition, are you aware and or present at an inspection of the property with the County Agricultural Council?
Yes, I was. I was present at that, and that field meeting with the representatives from the Agriculture Council was on December 7th, and I was present then.
And there was an Agricultural Council hearing on January 22nd, 2024?
That's correct. I was present at that hearing.
And what did the council rule with respect to the property?
What the council ruled, not with respect to the project, but to the property, is that the present property owner, under the Right to Farm Act, has the authorization, the standing authorization to continue to cultivate the property to the extent that he wants to cultivate it.
And does that mean, with respect to the property and how it's currently operating, it does not abide by the Stream Corridor Ordinance?
That's correct.
In accordance with the Right to Farm Act, do you know if there's a required buffer distance to a stream?
There is, under the Right to Farm Act, there is a required buffer zone to the stream, and that buffer zone is 35 feet.
Aside from the road that's proposed and the utility line crossings and the stormwater outfall structures being proposed as part of this project, does the project everywhere else accommodate at least a 150-foot buffer to all natural water courses on the property?
Yes, it does. You know, with the exception of those required encroachments for the roadway crossings, the stormwater outfall structures, utility line connection. On all other waters, it incorporates at a minimum a 150-foot buffer zone. In most cases, in excess of that.
I have nothing further, Mr. Cook.
Mr. Coyce?
I have nothing currently, Mr. Chairman.
Mr. Mayhew?
Thank you, Mr. Chairman. Mr. Cook, you discussed the encroachments proposed within the Hillsborough Stream Encroachment Corridor, and I think in the report that you recently submitted, you mentioned there were 2 sanitary lines, 2 roadway crossings, and 3 storm sewer outfalls. Would it increase, well, I think it might be helpful if we're looking at a plan showing those encroachments. Is it possible to put that up? I can tell you which drawing.
Which drawing is it?
It would be sheet 5 by Van Cleef.
Which?
It's called Overall Grading, Drainage, Utility, and Soil Erosion Plan.
I don't know if this is...
And I think, Mr. Giannetti, it was submitted...
What sheet did you say?
It's sheet 5 of the subdivision site plan set, and this was submitted back in probably early February. I'm unaware of any revisions submitted to the township subsequent to that.
Mr. Mayor, that's probably consistent with the wetlands permit plan, right? I would assume.
Probably.
Yeah, because nothing's changed on that, so it's got to be, that shows everything.
The beauty of sheet 5 is it shows the Hillsborough Stream and Corridor line. I don't know if the DEP wetland plan has that.
No. There would be more of an overall plan.
I'm trying to find the sheet.
Just based on, generally, you would keep scrolling down. It looks like you're at sheet 3.
This one?
That looks like it. And is there a way to eliminate the text on the left so we can see more of the plan? And since Mr. Cook, you were talking about the encroachments, I just want to talk a little bit about them. If we can zoom in, I'll follow the same pattern you're calling the smaller warehouse number 2. Mr. Giannetti, if you can zoom in a little bit on that warehouse.
Warehouse 2?
Yes, sir. And more specifically, if you can zoom in. And I wanted to talk, Mr. Cook, about the stream corridor encroachments that you mentioned that are proposed.
I got to have this thing up in order to zoom in.
We can see what I want to discuss. I'll start with there's a sanitary, the pointer won't work on the screen. If you look at the lower, I'm pointing towards the lower right corner of the proposed building, and this is what's labeled as the sanitary sewer
David,
lateral. And that's one of the.
we have a mic around here.
Quarter,
All right.
150-foot buffer. And just for the board and the audience, you mentioned, Mr. Cook, the two roadway crossings over the corridor. The reason for the sanitary connection into the corridor is to connect with the existing sanitary trunk line, which runs along the stream.
That's correct.
Could we minimize the impacts to the corridor if the sanitary lateral, instead of connecting across open land, was run under the roadway and made the connection at the existing sanitary trunk line that's already crossing the roadway?
Unfortunately, I'm not an engineer to design that, okay?
We can check that with Mr. Ford. I think that's better for our civil engineer.
Obviously, my recommendation is to minimize as much as possible. That question, why that wasn't done, I'm going to have to defer to the engineer on that.
Okay. My second question would be, there's a across the field, open field, storm drain coming out of one of the detention basins, also crossing the stream corridor, and it's just off another proposed roadway. I would ask, why wouldn't we bring that pipe and head wall right along the roadway and again minimize the impacts to the stream corridor that you were mentioning?
I like your idea. Yes, but from an engineering perspective, I'm going to have to defer to Mike Ford as to why that couldn't be done.
Okay.
Or why it wasn't done. I would like it. Yes.
Okay. And just for the board's use, the township has waivers for stream corridor encroachment, but they have to be proven that there's no alternative or prudent or reasonable alternative, and I think we're identifying potential alternatives. If we could scroll up in this area, you'll see there's a label called wetland swale, and it's crosshatched right here. And Mr. Cook, I think you mentioned there were some features that the engineer had labeled on the plan, and then when you got involved and did the site visit with the DEP, they decided not to call that a wetland feature at the time.
That's correct.
And I'm wondering, would it be a better design, instead of having the storm pipe coming out of the second detention basin for the warehouse, and it's crossing an open area in the stream corridor, could that outlet come over and exit into what's more of a natural drainage area, which is the wetland swale, and avoid another impact to the stream corridor?
Again, I hate to keep on deferring to the engineer, but I'm going to defer to the engineer on that. I like that idea so long as one of my main things from a as I was saying before, from a Bugs and Bunny standpoint, is I want to have something where we could have habitat that ultimately, if the project would incorporate it and incorporate and maintain grassland bird habitat up through that area. I would like to keep disturbances out of that area so that we could have one nice contiguous grassland habitat post-project. But I, from a ecological standpoint, don't see a reason why that couldn't happen, so long as it would not interfere with the opportunity to create and maintain some more grassland bird habitat there.
Yeah, I guess not only would it remove a pipe and a head wall and riprap from the stream corridor, but as you can see on the drawing, as it's shaded, there was a natural water course, I'll call it, which was labeled on the plan wetland swale, but as we pointed out, the DEP did not label it or take jurisdiction over it. But by discharging the basin into that feature, we would be more closely mimicking the natural drainage patterns of the site.
I'm in agreement to that, so make that recommendation to the engineer. I like it.
Okay. If we can move over to warehouse, so that would eliminate potentially 3 additional utility impacts to the stream corridor.
And if that's doable from an engineering perspective, Mark, I'm all for it.
If we can slightly take this drawing and scroll this area just to the left so we can see warehouse 1, there are 2 impacts to the stream corridor. One is the sanitary line coming out and connecting to the existing trunk line. The other is the storm discharge running down to the stream from the rear detention basin. I would ask, would it be better from an environmental standpoint to minimize impacts to the corridor and take this detention basin and drain it to this water feature that we've been discussing about all evening long? There's an existing feature here, and by draining to that feature, we would be minimizing impacts to the stream corridor, and we'd be more closely reflecting the natural drainage patterns that are occurring there. Would that be something you would support that idea as well?
I would support that idea so long as, from an engineering standpoint, and so that you engineers make your fancy calculations and everything, that the stormwater, if they use that route, that it could still have the that it would still comply with water quality treatment and so on and so forth prior to the discharge into the stream. So again, from a stormwater management standpoint, Mr. Mayhew, I know Van Cleve had to go through the stormwater analysis and stormwater report with the DEP and so on and so forth. I like the idea to minimize habitat disturbance, yes, okay. Did the project engineer have to accommodate anything specific based upon existing topo, DEP requirements or things like that? That I don't know. So for that, I'm going to have to defer to the project engineer on.
But it sounds like, Mr. Giannetti, you're taking notes and that this is questions that are going to be asked, because at some point, if the project continues to proceed, the board would be asked to grant waivers to these stream corridor impacts, and I would think you'd have to demonstrate there's no other reasonable alternative. Mr. Cook, you mentioned the impacts of the current disturbances within the stream corridor surrounding the water feature on Lot 33 that we've been discussing for the last 2 meetings. Is it possible that there could be a project proposed with development that removed some or all of the existing disturbances within the stream corridor?
Are you going to object to that?
Say that again?
This would be, I guess, a hypothetical.
I would be speculating on that. Like,
I'll just make it shorter and rephrase it. Is it possible to develop Lot 33 with improvements that removed the existing disturbances within the stream corridor if it was imposed on the water feature in question?
Yeah, I'm going to object to it as speculative and doesn't have bearing on this application.
You're advising your witness not to answer, is that what?
Yeah, I'm objecting to the question. He's having him speculate on some other development that's not being proposed as part of this application. He's not our civil engineer, he's not our planner, he's just our, not just, but he's our.
Just a Bugsy Buddies guy.
He's our environmental wetlands consultant.
So the answer is the witness is not capable of answering the question, and you're advising him not to answer the question.
Yeah, I'm objecting to the question.
That's all the questions I have right now, Mr. Chairman.
Okay.
Mr. Chairman, if I may? Could you go into more detail? You're talking about, and please correct me if I'm wrong, but my understanding is you were talking about how the site layout and design basically creates a better idea of habitat and bird habitat and things like that. Can you give a little bit more detail in terms of if this development was to go ahead and be approved and built, what sort of things would be put in place that would help protect that? Are you proposing any sort of conservation easements or maintenance plans or anything that would show that the bird habitat would continue? Just trying to understand the difference between, if there is one, between when you're saying about site design and layout, but then, years after this development, if it's potentially built, are you saying that it could still be a bird habitat, and how would that happen?
Gotcha. Great question. Thank you. First and foremost, with regard to this property and the habitats that are there, okay? Unfortunately, at present, based upon past use, past disturbances, and so on and so forth, a lot of the actual good grassland bird habitat has either naturally succeeded to a later stage succession, which is no longer suitable for them, or the areas that are still potentially suitable for them are now basically taken over by alien invasive species, which is common in an area that's disturbed from farming or whatever, without proper maintenance. Okay, that's what happens. Unfortunately, what happens in damp areas, Phragmites grows. What happens in dry area, alien invasive mugwort grows. Okay, what this would have an opportunity to do, if the applicant doesn't strangle me or whatever, but my recommendation when I see something like this is I see the potential for improved grassland bird habitat there. And the way that we would get improved grassland bird habitat there is actually with the management of that. And that management for grassland bird habitat's pretty easy, okay? Right now, it's all mugwort, alien invasive herbaceous species. Once a project would be completed and done, those areas, they're going to have to deal with some tree planting and so on and so forth, which my recommendation is going to be around the stream corridors and so on and so forth. But in the other open areas, to have a natural meadow mix planting there, okay? Have that natural meadow mix planting there, and then have a management plan. And that management plan can be nice and simple. A cutting every 3 years, and a timing of the cutting. So you would time that cutting after grassland bird nesting season. Okay, you have the control of that. Unfortunately, with farming, you don't have that control. Okay, so that's how I think that this could easily incorporate a lot of acres of restored good bird habitat that's better than out there right now.
Thank you. Just for the board's clarification, just want to make sure or understand the differences between what you're saying in terms of the benefits of the design, but then what is the applicant actually proposing? Are there any conditions to put that into place, or are you just stating for the record that the design and layout was done in such a way where there's the benefits that you mentioned? It's just, I don't want there to be any confusion, or I'm trying to avoid any confusion even for the public when hearing your testimony about the benefits to the bird habitat, and then ultimately there's nothing in the plans from a landscape planning, from a maintenance standpoint, there's nothing stopping what you testified about as a bird habitat and it becoming not a bird habitat. So again, not making you do anything, I'm just asking for clarification. What are you actually proposing to the board so that they could be clear?
Okay, let me answer that in two parts. Number one, the first part was the design, the overall layout. And that overall layout allowed for the opportunity for large contiguous area of that property, okay, that is presently in mid-successional field, early to mid-successional field area, to remain, so that that area is not fragmented by a building, so that we have a contiguous habitat. That was part number one. Get them to design it the way that I would want them to design it if they're going to develop this thing, okay? Secondly, after that, from a planting standpoint, that's my recommendation from a landscaping standpoint that they ultimately incorporate.
Okay, thank you.
We would agree to that as a condition of approval.
Thank you.
Thank you.
Nothing else, Mr. Chairman.
Board members?
I have a question about this last piece. Sorry about that. My question about this last piece out here, right? If we at all get a plan going, I understand the design piece, but after that, there is a maintenance piece going on, right? Will this entire thing have some kind of a mechanism to administer that? Like, say, for example, grass cutting that you said, right, has to be done every 2 years, a year. What if it isn't done? Will there be any, I don't know, penal clauses or anything? Like, how would that be administered? Because I think it is a long-term viability which...
I would assume that those kind of conditions would be put in from a landscaping standpoint and then from an overall property maintenance standpoint. And conditions on, number one, from a landscaping perspective, what to plant, what meadow mix to plant there, okay? And secondly, to incorporate into the management plan, how that would be maintained, just like they would have to maintain the trees that they would plant and so on and so forth. That would obviously, could be required to be put into a maintenance plan. So it's understood. So it's understood that it doesn't get cut every year, okay? That it gets cut every third year, every fourth year kind of thing.
And we would agree as a condition of approval, similar to like how the stormwater management, there's an operations and maintenance manual that's recorded, that we would record some sort of bird habitat maintenance covenant for the benefit of the town and record it on the property for that area.
Thank you.
Thank you.
Mr. Cook, hi. Can you clarify what you said about the 150-foot corridor and the ditch and the existing house and facilities? I made a note on that, but I want you to clarify what you had said about that.
Sure thing. The subject ditch that we're talking about is that feature presently on lot 33. Okay, that originates at the outfall pipe and flows in a northerly direction. If we incorporated the 150-foot stream corridor around that ditch, what my comment was the characteristics of the land that would be incorporated in that 150 feet around that ditch include existing impervious parking area, existing impervious equipment storage area, a lawn, house, solar panels, things like that. It does not include natural habitat characteristics within there.
Okay, thank you.
Thank you.
Anyone else?
Thank you very much. Mike Pissarro again from the Watershed Institute.
How you doing tonight?
I'm doing well. Yourself?
Good. Doing good, thanks.
And since we're on this, and Mr. Giannetti, if I could impose, could we sort of focus a little bit on that constructed wetland 2B for a second? That area?
Generally where?
If you could just enlarge that northeast corner a little bit, or northwest corner, the left.
You're saying a constructed wetland?
Yeah, so right there is the below warehouse 2's pond constructed wetland 2B.
Okay, so that's within their stormwater detention basin. Gotcha.
Yeah, and I just wanted to enlarge that to show a little bit of the surrounding area. so that everyone can see.
Is that,
If you could put the constructed wetland a little more in the center of the screen and then enlarge it a little more, or I'd be more than glad to take over responsibilities of that.
hook this up, you mean?
Hopefully I can do that.
We're looking at this area right there, right? That stormwater detention basin under there.
That should be fine, I think. Thank you.
It says the thing that says bioretention system 20?
Yep. Actually, I can't walk with that one. All right, thanks. So if I may, sort of in the center of the screen is bioretention system 20. At one point it was labeled constructed wetland. And you had testified that it was your recommendation to your client that we make as large of buffers as possible.
That's correct.
Okay. And you would agree with me, there's a line, and I'm sort of tracing it. It goes through the road, sort of cuts the corner of the stormwater basin, and sort of hugs this stormwater basin, and that's the Hillsborough Township Stream Corridor Ordinance.
That's correct.
And it's right up there.
That's correct.
All right. And that line continues and also stays relatively close to the corner of the building and then goes a little bit wider.
That's correct.
So we're right up against that buffer.
In that area, yes.
Yeah. And if you could go back out. And this site has a lot of environmental features. You would agree with this?
Define environmental
It has
derogatory or advantageous.
I'm an environmentalist. I would call them.
Yeah.
But it has a stream. It has several tributaries.
Yes.
And they all have their own corridor, buffer, whatever you want to call it.
Unfortunately, the smaller tributaries don't at present have a big vegetated, forested buffer as much as I would like, but they're there.
But DEP, DRCC, the Hillsborough Township Stream Corridor Ordinance all would have these buffers.
Of course.
And that takes up some amount of the land that would be available.
Correct.
And there is running through basically the center of this site from southwest to northeast a gas easement, correct?
Correct.
So that takes up and you can't build on that. That would be.
Assumes, I assume so.
Okay.
Yeah.
All right. Did you have any discussions with the applicant about building a building on the Texas Eastern line there?
I'm going to object. It's outside of the. I'm going to object. It's outside the purview of his testimony. He didn't discuss the easement or developing on it, or whether we could or couldn't.
I'm asking whether he did. If I recall correctly, you spoke to someone about this project, whether it was the applicant or the engineer or someone, about making sure you had as large of buffers as possible.
That's correct.
And staying out of the environmentally critical areas. All right. If we could go to warehouse 1, please. Very good. And so with the bioretention system to the north, right above, again, the Hillsborough Township Stream Corridor Ordinance really just hugs that bioretention basin, correct?
In portions of it, yes.
And also is relatively close on the eastern side of the building as well.
That's correct.
All right. And the Texas Eastern pipeline easement, again, is shown just to the north left of that building, relatively close, correct?
Correct.
All right. Thank you. And so we had a series of questions from Mr. Mayu about the drainage feature on Lot 33 that has consumed lots of time.
That it has.
And you, in your report, and you've just testified that it either is an environmental degradation or we fill it and manage it with stormwater. Is that paraphrasing your position?
No.
No?
What I said was, at present, that ditch is conveying untreated stormwaters from impervious surfaces that have vehicles on it directly into the tributary of Royce Brook, which I consider critical ecological value.
And by enforcing through this development application, the stream corridor ordinance, so that the stream or the feature remains, the 150-foot buffer remains, and some development continues in a modified manner, would not the stormwater be managed from the revised plan?
I'm going to object again, being speculative, as to some other hypothetical plan that's not the subject of this application.
All right. You've opined that New Jersey stormwater control regulations are the strongest in the nation.
Correct.
Would you agree that the stormwater rules, and as this project implements them, there will be an increase in volume running off a site, even if it is managed through stormwater?
I'm going to defer to the project engineer who dealt with the stormwater management plan.
You wouldn't disagree if he had testified, yes, the volume would increase?
I did not hear his
Object. I think he-
testimony, so I can't agree to something I didn't hear.
All right. All right. And do you know when that parking lot was created that allegedly drains into this feature?
Oh, it does drain into the feature because it has graded inlets that are in the middle of it that discharge into the pipe that discharges into this ditch. No, it was later than the 60s because it doesn't show up on the soil survey map.
Did you look at aerials from the 70s, 80s, or 90s?
Yeah.
Do you remember when it shows up?
I don't know. It was, I believe it was later into the 70s that started showing up.
Okay. And in your report or your supplemental report, you would agree with me, there are no aerials provided.
Correct.
All right. And in your original report and your supplemental report, there are no photographs of this area.
There were photographs of the area in my environmental report given to the DEP in support of the freshwater wetlands protection, the freshwater wetlands general permits.
So, but my question is, in your ERI that you submitted originally for this project, and in your supplemental report that was submitted on the 23rd, I think, there are no pictures of this feature.
No.
All right. All right. And did you do the soil testing for hydric soils for the wetlands delineation?
For the original delineation, I did not do the original delineation.
Did you do any?
I met with the DEP to review that wetland delineation.
So you didn't do the soil testing, and did you do it for this feature?
Yes. When I was meeting with DEP out there, see, originally this feature was not included in Van Cleve's original wetlands LOI submission. Again, I didn't do the original wetlands letter of interpretation. I didn't do the original delineation. I was asked to represent it because I was going to be representing permits for the project. So they chose me to be the lucky one to meet with the DEP. During such time within that ditch, yes, we took soil samples between myself and the DEP, and yes, they were hydric soils in there.
Is that anywhere in your report?
No, it's referenced as a regulated wetland by the Wetlands LOI. I think that says it all.
But the soil results aren't in your report?
No, they're not.
Okay. All right. And any plant survey done in the area, other than you reference it being invasive and mugwort, is not in your report?
That's correct.
Okay. All right. I think you testified in your report, you mentioned you've been on the site several times.
That's correct, yes.
In the parking lot, were there any vehicles parked?
Yes.
Do you know, were they septic company trucks, or were they normal passenger vehicles, or what were they?
They were trucks. I believe there's a landscaping business there, and there were vehicles for that.
Okay. All right. At the January 25th hearing, you indicated you had conversations with Mr. Shockley about this feature being man-made.
Correct.
Did he tell you that he made that ditch or had it made?
He said he had it made.
Okay. All right. And at the January 25th hearing, you noticed, or you testified that the water course has a headway and there are inlets in the surrounding area that presumably discharge. Is that accurate?
It has a head. It has an opening, a pipe outfall. Correct.
Is it a head wall or is it just a pipe?
It's just a pipe.
Okay. And on the existing features map of this site, is any of that noted? Do you know?
And the existing features, I believe it would have been noted as topo on Van Cleef's existing features plan, because remember, that was not originally included as a jurisdictional wetland. So I believe Van Cleef probably denoted it as a topographic feature.
But, so, let's see. Mr. Giannetti, if you could put up sheet 2, the existing features.
And what's the question?
Sheet 2 of the existing features of the site plan.
What's your question with respect to sheet 2?
Well, this diagram or this site plan shows buildings and other features on the site, correct?
I think he's looking for the existing
Yeah,
feature,
yeah,
not the
I do.
proposed. There you go.
Oops.
No, you're going too far.
Yeah.
Go over to the, make it go to the left. We're looking at this, right?
Yes. Yeah. So that site plan, the existing features, demonstrates various structures on the property, correct?
That's correct.
And if we were to scroll down to the road, it would show inlets from the road.
Yeah.
My eyesight's not what it used to be.
Yeah, I don't know, 'cause I think
Yeah.
Probably any inlet from that road would go right down to that tributary, probably. I don't think it would cut across the property.
All right. While it's not clear, you wouldn't disagree with me if I said the plans show inlets from the road? You wouldn't have any reason to disagree with that statement?
I'm going to object to the question. He didn't prepare this plan.
All right. Did you review this plan at any time, Mr. Cook?
Yes, I did.
Okay. You would agree with me, none of the inlets in the field show up there that are allegedly discharge into the feature?
On this plan, that's correct. I don't see any that show up on here.
Have you seen any plans that show them?
No.
All right. And I apologize, I'm going to jump around a little bit again. You mentioned one of the things you recommended to the client was that, all crossings of the stream be as close to perpendicular as possible.
That's correct.
That's a requirement of the Flood Hazard Area Control Act rules, correct?
To the greatest extent possible,
Okay.
yes.
So, in short, you told your client comply with the rules.
That's what I'm supposed to, yes.
Yep. All right.
Yeah.
It's better than not comply.
It's better than not comply.
Very true.
Trust me.
All right.
But to stay within the limits of what's permitted now under an FHA IP or freshwater wetlands general permit, that does give some flexibility to the engineer to design that. Again, my recommendation was obviously minimize disturbances.
Okay.
It better for the environment and better for the permits.
All right. And I think you testified, but I want to just double check. You think there is value to the Hillsborough Stream Corridor Ordinance from an environmental perspective?
Oh, most definitely.
And that you would agree with me that wider buffers, by and large, are better than smaller buffers?
So long as we have a resource that we're protecting, and so long as the characteristics of that buffer are beneficial.
And degraded buffers can be restored?
Sure.
Yep. All right. And so buffers provide benefits from water quality, correct?
They can, yes.
They provide temperature regulation if there are vegetation, especially trees, to a stream.
That's correct.
All right. And they provide slowing down of runoff because it's being run through vegetation and uptake through evapotranspiration. That would be correct?
That's correct. You're
right. And you would also agree that the DEP Flood Hazard Area Control Act had a model riparian zone ordinance. Are you familiar with that?
Yes.
Okay. And that ordinance specifically mentions townships, municipalities can be stronger?
That's correct.
Okay. All right. All right, I think that's all the questions I have. Thank you.
That's it? Oh, my God.
I try to be concise.
Thank you.
I don't always accomplish that.
Thank you.
All right, and with that, we're going to take a brief recess. We'll reconvene at the top of the hour at 9 p.m.
Mr. Cook, you said that you recommended that the applicant increase the buffer. And can you tell me how many times they did that and by how much?
Just from an overall standpoint, sorry about that. I don't have a count on a number of times. It was what they've done is to incorporate an increased buffer zone wherever they could on it.
How many feet extra?
In some areas, it was no increase over the regulated stream corridor. In other cases, it was probably in excess of 50, 60 feet in some areas. It was basically what they could accommodate.
And how many instances was that?
It was throughout the project.
You'd have to look.
We can see on the plan.
You said you did 4 site visits to the site, right? 4 visits to the site?
No. I was on the site in July of 2021. I was on the site multiple times in November of 2021, October of 2022, November of 2022, March of 2023, June of 2023, December of 2023, and January of 2024.
And what does that add up to? I'm not good at math.
A lot, because there were multiple visits during those times.
Okay. And on those site visits, when you looked at the so-called stream/ditch, how many times did you observe it to be dry or wet?
When we were with the time when I was meeting with the DEP, it wasn't inundated, but it was quite saturated, and that was in March of 2023.
So one time you recollect?
Correct.
Okay. And do you have photographs of that?
No.
No. Okay. The township engineer's report included maps from 1943 and from 1963. Mr. Coyce, is it possible to put up the 1943 map?
I don't know.
I do not have that information.
It's on the civic.
I don't know. What map is this?
Sorry, which year is it?
It's on the Hillsborough Civic site.
For this application?
Yeah. It was a Pannoni report.
Is that in your report, Mr. Mayhew?
I believe she's referring to a letter that Pannoni wrote to your office and the board. And possibly, it might be back in September, possibly. And
Do
there
you
were.
have that letter with you?
It's on the website. I don't have a computer.
It's so I
You
believe.
have one, right? You could find it.
I don't know what letter you're referring to.
We
Go
are
on the
going to
civic
try.
site
Do you know,
and
Mr.
look
Mayhew?
for that report.
Too much stuff is on Civic Clerk. There's a lot of stuff here.
Why don't you try to find Mr. Coyce and want to
You know where it is.
ask additional questions so that we...
Is it from August? September 23?
That sounds potential.
Is the screen,
And there would be attachments to
working?
the letter. I believe there's a letter dated September 22nd. We just referenced stream corridor in the letter of 22 September 2023. It's a 4-page letter with
which
6 exhibits.
Keep going. Keep going. Okay, so this is, one of those is from 1943 and one is from 1963. So the one before this, could you go back? Keep going. Okay, no, go back. The colorful one. Okay, Mr. Cook, did you look at this map from 1943?
I have not seen this map.
Okay. And what does this map speak to you about? What does that blue line look like to you?
It's labeled as drainage feature, and this is from 1940s.
43.
Yeah, 43. I would have to say that the historic aerials from 1943 and the old Vermeule maps never showed features that were that small. So I'm not sure if this was added in or not.
Did someone draw that line? Because this says natural
Photoshopped
draw.
in, or what? What are you talking about?
Mr. Mayhew, this is your,
Allow me to clarify, that's correct. This is an exhibit that we created for the letter. And as Mr. Cook has pointed out, this is from 1943 aerial. The natural draw drainage feature was drawn on by our office. And it's in the letter, it mentions that it was drawn on and added to the plan.
So you're saying that the owner, Mr. Shockley, built this ditch or stream or whatever?
No.
You're saying he did it? You testified that
That's
he
what
said that he did it.
said that he had created that ditch.
Is it possible that, when did he purchase that property?
I don't know.
Is it possible that the owner before him enhanced this water course? Is it possible that this water course was a watershed and was indeed a natural depression where there was water, and then humans came and
Ma'am,
added the pipes and all of that stuff?
I'll before Mr. Giannetti, that is a compound question. If you can try to break it up into segments, not that Mr. Cook will any more answer it now than now, he may be able to answer, but you're asking multiple questions in the same question.
Thank you.
Not a problem. So start where you.
I understand what she's asking.
Okay.
What I think one of the best examples would be to review the soil survey map of the property from the Somerset County Soil Survey. What's nice about that is that the soil surveys back then, they incorporated streams, they incorporated drainages, and so on and so forth. And what they even did, not that they were ever meant to be regulatory, but the old soil surveys were made for farmers. Okay, they were never thought that we would be discussing soil surveys now with regard to development. They were meant for farmers. What they did on a lot of the soil surveys is if there were drainage patterns and so on and so forth that a farmer would need to see, they would mark it, not to be regulatory or anything like that. If you look at the soil survey of this particular, the sheet that has this property on it, there is no indication whatsoever on that soil survey of any kind of drainage feature in this location.
What was the date of that survey?
Soil survey of Somerset County is... let me see my references here. Just for my familiarity with it, it's definitely in the 1960s. Unfortunately, I don't have that date of the Somerset County Soil Survey with me.
Can we look at the map past this? That's a 1963 map, the one below it. Bring it down just a little bit. Yeah, so do you see the depression there?
I see a change in vegetation, yes.
So there was likely some sort of ravine there.
I think the normal topo, the topography, generally went down through that area, so it looks to me to be the beginning of a hedgerow of some sort there.
So it could have been a wetland that was enhanced, well, maybe that's not a good word, but denigrated by the current owner or the owners before.
I think I'm going to have to defer to the analysis and evaluation of the New Jersey DEP, who did not classify this as a water in accordance with the FHA verification. One of the things that they look for in that is any reliable evidence that something could have been a former manipulated stream. And a DEP in their FHA verification did not include this as a regulated water.
Isn't that the crux of the issue, whether it's the jurisdiction of the town or the DEP? You're speaking as if the town is saying that they have jurisdiction. Is that correct?
Actually, no, the DEP has jurisdiction of that feature, not in accordance with the Flood Hazard Area Control Act rules. The DEP determined it was a jurisdictional wetland, okay? So that feature is considered as a regulated wetland, so it is a regulated feature in accordance with the Freshwater Wetlands Protection Act, not the Flood Hazard Area Control Act rules. And the Freshwater Wetlands Protection Act, they utilize that to incorporate that as a ordinary resource value drainage ditch.
So why is the town saying they believe it needs a 150-foot buffer?
For the same thing that I testified before, the town's definition of a stream is very vague, okay? You know, the town's definition, if I may read it, and this is, you know, and I'm not knocking the town, okay, because I like the town stream corridor ordinance and stuff like that, okay? But, you know, unfortunately, the town's definition of a stream is a watercourse having a source, a terminus, banks, and channel through which waters flow, okay? That's very vague, okay? Any roadside ditch has an origin, a terminus, banks, and a channel. You know, so that's, you know, I'm not going to say what the writers of the definition, you know, were implying about what a stream is in Hillsborough back when that definition was made. But like I said before in my last testimony, I think the word that's being used there, watercourse, generally when one uses the term watercourse, it's generally referred to as more of a natural feature, not a man-made, narrow, linear stormwater conveyance feature.
Is this possible it was originally a natural watercourse and changed significantly by the current owner who said he did something to it?
I don't believe so, and the DEP doesn't believe so.
Okay. You spoke to working with Peg Van Patten.
Yes.
Are you familiar with the Greenways map that she was responsible for developing that shows this site?
Yes, yes.
Do you have a copy of that?
Not on me, no.
And you consulted that?
I looked at that through, and that was actually referenced in the Hillsborough Township NRI.
And what did that Greenways map say? Can we get access to that map, David?
Is it?
Not part of the application.
Yeah, so, no.
Mr. Chairman,
Right, it's not in Civic Clerk, so it's not part of the application at this point. Yeah, as the witness said, he just made reference to it in his report, so.
It's referenced in your report?
No, I had reviewed it, but I don't have any.
I
don't have any specific reference to it. Right, I deal more so. You know, those old mappings and so on and so forth they're useful from a planning standpoint, they're useful from a master planning standpoint, and so on and so forth. The problem that I have with ones who rely solely on old mapping and old generalized mapping is a lot of times that they use that in lieu of actual boots on the ground field evaluations. The reason I can make my recommendations to this development and about this property is because of boots on the ground, where real corridors are on this thing, where degraded areas are, where areas that should be considered per this property as critical resources.
I'm a little confused by your saying that the current stream/ditch is putting a lot of pollutants into the watershed. Is that correct?
That's correct.
Okay, so wouldn't the owner have to fix that?
No.
No, they could just let all of that stuff go into a man-made
If it was
basin or
if
whatever
it was
it is.
done before regulations and so on and so forth, would that be permissible today? No. Do these things occur? They occur everywhere, unfortunately. One of the that's what one of the issues is with our some watersheds and so on and so forth is until you can identify these point sources of degradation, they can continue to go on. There's he was entirely permitted to do so, and there's no regulation that says that you have to change it.
Are you aware that this site was cited for pollution issues?
I know that they had contamination issues. I don't know exactly where that is because that's not my specialty. Okay, but there is remediation requirements on other areas. I think because of Hog Farm.
Anybody looking at that, attorney?
The DEP
We
is.
had a whole witness come and testify as to that.
You're having witnesses?
No,
go-
he already came and testified.
They already came, okay. So you're saying that if this development is built, that it will, that degradation, that pollution will go away because a building is going to be built on top of it?
At present, untreated stormwater from vehicles parked on an impervious surface are going into drains and draining directly into this ditch, which is going directly into the tributary of Reese Brook, okay? That's what's happening today, that's what's happening tomorrow, that's what's been happening, okay? When a project comes along, such as this, that triggers stormwater management, what they have to do is they have to abide by the state's regulations today, okay, what that is today. So that means post-project, two things, or actually three things with the stormwater management regs. They have to deal with quality, they have to deal with flood control issues, and they have to deal with recharge issues, okay, which in the past they didn't have to do. When they developed this site before, they didn't have to do that.
So
now
the
they will.
current owner over here, I guess you're the owner or sort of the owner, I'm not really sure, but.
I don't know who you're pointing to, but no.
It's a big question. They have no responsibility for the quality of what they're putting into the watershed.
That's correct.
Wow. Okay. You said something about the right to farm?
Yes.
So they have the right to do whatever they want? That's not a farm, that's a septic system.
No, we're not talking about Lot 33 now. We're talking about Lot 32.
The other one.
Right, which is what I know as the Kersner tract, okay? So under the Right to Farm Act, that has farmland tax assessment. It was utilized as a farm, as a pasture, as a hog farm. And under the Right to Farm Act, it was decided by the board that they have the right to continue to farm it and to farm it as they see fit.
Okay, that's all I have. Thank you.
Thank you.
Good evening, Mr. Cook. Scott Gross.
Hi, Scott, how you doing?
Objector number 2. Fine, thank you. I'm going to refer back to your original report. Your December 2021 report evaluates the potential for air quality impacts, correct?
It's summarized at that particular time, correct.
You mentioned after construction, the largest air quality impacts would be from vehicular traffic and heating. Is that correct?
That's correct.
How did you evaluate the air quality impacts from heating?
For the purpose of that, at that early stage of the game there, those were based upon general determinations with regard to what proposed use would be and so on and so forth. There was not specific air sampling or things like that. It was based upon relationship to existing roadways and so on and so forth.
You said an initial assessment. Does that mean there will be a subsequent assessment?
There has been a subsequent assessment. That subsequent assessment was done by RTP Environmental Associates dated August 31st, 2022, which I believe the township has. And that was called air quality analysis, and conclusions that it had was that the proposed use at that particular time would not be a significant degradation to the air quality.
Okay. Your report also addresses noise generated by the facility, correct?
That's correct.
You mentioned that noise from site operations would be insignificant compared to noise from the 206 bypass. Does that sound correct?
In general, yes.
On what basis did you evaluate the noise from operations?
Again, this was general in nature at that particular time, not knowing the exact project, routing or things like that, but that's generally based upon noise levels on the property at present, surrounding noises, and what potential could be.
Was there a subsequent report included in the other assessment that we talked about, like there was for air quality?
There has not been.
Did you evaluate noise or potential for noise from backup alarms on trucks?
I did not.
Did you evaluate any noise with any technical measurements?
I did not.
Do you have experience evaluating the noise?
I do not.
From warehouses? Okay. Are you aware of the New Jersey State Guidelines for Siting Warehouses? It was published in September 2022.
I'm going to object again. We've gone through where individuals are trying to use that document. It is a document issued by the State Planning Commission. It is recommendations. It is not binding, and it's not for planning boards to be used as part of considering their application. Planning boards review the site plan ordinance. It's for governing bodies and or counties in determining zoning with respect to warehousing.
Are you saying that you're recommending we don't follow the state's guidance on siting warehouses?
What I'm saying is it's not what the planning board follows in determining. This is not a quasi-judicial body. It's a planning board. Sole question is, do we comply with the town site plan ordinance?
It is a quasi-judicial body.
No, the zoning board.
The answer is the state planning guidelines are exactly what they are. They're guidelines. The board is not going to ultimately determine your client's application based on reliance of the state planning guidelines. If the objector wishes to question your client on his knowledge or lack thereof regarding it, he's permitted as it relates to his testimony. It doesn't mean that the board is going to be bound by the state planning guidelines. If Mr. Cook has little to no knowledge, and he has been very forthright in telling us when he has little to no knowledge, then he can answer the questions. But frankly, spending time telling him he can't, unless you're going to tell him not to answer them.
I'm almost done. I'll be brief. At least with respect to noise levels, and I think Mr. Cook will agree, the conclusions are relatively thinly supported compared to some of the other technical analysis that's been done for stormwater retention and calculations. And we've got scores of calculations to support some of the other work that's been done on the project. That's why I'm deferring to the state's guidelines on noise impacts. I guess I'll just ask one last time. Do you have any technical evidence to demonstrate that you've performed a noise impact analysis of this property and the surroundings?
I'm sorry, could you repeat?
Do you have any technical evidence that supports a noise analysis of impact on the surrounding community?
I do not.
Okay. I'm done. Thank you.
Thank you. Bless you.
Sorry. Lucy Sandler, Sauerland Conservancy.
Hi, Lucy. How you doing?
Good. How are you?
Good.
Okay. So during your testimony, you mentioned several times grassland birds and wanting habitat for them. Why the focus on grassland bird habitat specifically?
Well, first of all, because we have an area that at one time or another in the past had open early successional field habitat associated with it. It does still have some early successional field habitat associated with it. Unfortunately, today it's dominated by alien invasive species. Grassland birds, again, are a species of interest to me, obviously, simply because of the loss of habitat and so on and so forth, and the need to manage habitat in order to keep them viable.
Mm-hmm. In the environmental impact statement prepared by Redcom Design and Construction LLC on page 4, it's...
I'm not Redcom.
I think you might be looking at the wrong...
Oh, my apologies then. I can actually skip that one. I'll go to a different one.
I'm Ed Cook.
Sorry, so did you not have to review that document, or?
Redcom is not associated
This is not the Redcom application.
Oh, okay. All I wanted to mention from that is just on the project site, do you agree that there are mammalian, reptile?
No, objection. That's not our application, that report.
I'm saying never mind about that. I'm asking a separate question.
All right, what report are you referring to?
No report. I'm asking him a question.
New question. Got it.
New question, yes. Scratch that.
I'm with you.
Okay, great. Do you have any concerns that developing the project site as planned will reduce habitat for traveling animals and could have a detrimental effect on their populations?
This overall property is, it's got a nice wildlife corridor associated with the tributary stream. Okay, that's why I consider that thing to be extremely important. I like that. It's big, it's wide, it's got an aquatic resource associated with things like that. The property overall it's sort of a large, isolated area. Developing this site is going to impact the site itself, obviously, because you're going to put buildings on something that could be habitat, and that's going to impact it. That's what happens. The development of this site is not going to fragment any larger corridor because it's not, it's not part of a larger overall big corridor. Where the corridors is associated with that stream, and even on a microcosm, so to say, what I want to try to form on this thing post-development is that if they're going to develop it, to incorporate some type of habitat corridor, which is what stemmed from my recommendations on any kind of site layout and so on and so forth.
You mentioned that the site is not near any major wildlife corridor, and that is true. Because they're shrinking. There aren't any major wildlife corridors at this point near the site. But
Correct.
It is less than a mile away from one of the last remaining, however narrow it is, wildlife corridors in central New Jersey. Are you aware of that?
Yes.
Okay. The project site is located directly within an area that's identified by the state as an action region, which means habitat and wildlife corridors are deteriorating in those areas. You are aware of that?
That's correct. That's what development does. Yeah.
So can you just explain why it makes good ecological sense to further degrade already shrinking habitats for transitory and migrating wildlife by developing the project site at all?
Well, first of all, as you heard from my earlier testimony and everything, the characteristics of this site, okay, it's, how do I say it? It's not as good as I wanted it to be, okay? This site itself, the problems with it are, you know, part of it is developed in the eastern corner, okay, the southeastern corner. Part of it used to be a hog farm. There used to be a lot of disturbance associated with it. In the central region of it, there's a lot of disturbance to it, okay, which is, you know, used formerly as a pasture and as a hog farm and so on and so forth. Resulted in today, what we have out there is you know, we've got area and we've got tributaries and we've got, you know, things that I consider as important. But overall, the majority of it, you know, where we're dealing with mid-successional field, for instance, you know, what that is today, multiflora rose, Russian olive, Crataegus, okay? In most of our, I'm sorry that you have to type these things. I'll try not to speak Latin. In the areas that would be considered as early successional field, okay? I don't have orchard grass and alfalfa and so on and so forth. Instead, I've got a predominance of mugwort, okay? In any damp areas around there, okay, do I have sedges and rushes and sensitive fern and things like that growing? No. I've got Phragmites growing, okay? So overall, the property in its present state, you know, doesn't support or it doesn't present the highest quality of habitat components that we would like it to on its own, okay? So, you know, if we left it alone right now, you know what's going to happen to it? More Russian olive is going to grow without maintenance, okay? More Russian olive is going to grow. More mugwort's going to grow. Or what's going to happen is under the Right to Farm Act, the farmer is going to farm it. And again, if there's any farmers in the audience, I am not against farming. I'm not against developers, okay? But I am going to say something. Farming operations are one of the worst things for water resources, okay? And you understand through the Right to Farm Act, you know what kind of buffer zone he has to accommodate? 35 feet from a stream, okay? Within 35 feet, we can unregulate it, apply herbicides, pesticides, not to mention erosion, okay? That's what happens, that's another alternative that happens to the site if left alone.
Do you consider this like a lesser evil? Kind of all the ways development could happen on this site, this is if development has to happen, this is like the best case scenario? Is that what you're kind of getting at?
I'm the Bugs and Bunnies guy. I would like to see everything. I would like my house to be the last house. I'd like my office to be the last office, don't we all? Okay. Unfortunately, because of master plans of municipalities and zoning and you know, constitutional rights to use properties, they get to be developed. That's where what I could do is two things. I can make regulatory, you know, inform about regulatory compliance, and I can inform about, you know, if it has to be done, the best way to do it.
Thank you. Just a couple more. From your report, table number 4G.3.
The supplemental or the original?
That would be the original.
Yeah. I was saying, I'm not sure, so I'm glad you knew. Thank you.
That's 4G.
Dot 3.
4G.3. Gotcha. Avian species?
Yes.
Gotcha.
So you take the time to talk about the habitat potential on the project site and go over species that either have been observed on the property or could be.
Or could be, yep.
So one of those species that was actually observed is the sharp-shinned hawk.
That's correct.
Okay. Are you aware that that bird is considered a species of special concern by the state of New Jersey?
That it is.
Okay. I want to understand what the professional versus purely ecological line is when deeming development not detrimental to wildlife. So, given that the sharp-shinned hawk isn't considered threatened or endangered at this point, but is on its way there, as an ecologist, why are you comfortable reducing their habitat by any amount? Simply because it's your job, you kind of have to, or?
No, I'm not promoting development. I'm doing an ecological resource and making recommendations on if something has to be developed, the best way for it to be developed. If you notice in there, what I'm saying is that sharp-shinned hawk can utilize any of those habitats, but where did I find it? I found it in the stream corridor. Okay, the stream corridor habitat, which is associated with the forested area, which is more sharp-shinned hawk habitat. That's where it is, proving my point, to my recommendation that not only because of a water resource, but that stream corridor has a good wildlife resource associated with it.
If the sharp-shinned hawk was listed as threatened or endangered, would your recommendation about this site change, and if so, how?
No, it wouldn't. Simply because as I said before, the existing habitat characteristics on this particular property are not prime, okay? Some of them are below marginal, okay, when we have a predominance of alien invasive species, both from ground cover and a shrub layer. If this was entirely wooded, well, I'll even backtrack. One of my recommendations on why the stream corridor is so important is because it's wooded habitat, okay? Sharp-shinned hawks prefer wooded habitat, okay?
All right, and then, so on page 40 of your report.
Same report.
Yes.
Page 40. Avian species potential is the same thing.
Here we are again.
Here we are again.
Notes the avian species potentially associated with the site, and it includes the bald eagle. Did you observe a bald eagle when you were on site?
I did not.
Okay. Page 45 lists rare wildlife species, obviously including the bald eagle. Could you briefly explain what an S rank of S1B, S2N means for the eagle?
We're on page 45?
Yes. And I can repeat that, apologies.
That's all right. Page 45 was the New Jersey Natural Heritage Program database review?
I'm looking for the list of rare wildlife species. Perhaps I have the wrong page.
Let's see where we are.
I can skip it if it's too much of a headache.
You can ask me about bald eagles. I'm cool
I
with
was
that.
just curious if you could explain briefly what an S rank of S1B, S2N means regarding a bald eagle.
Those are state rankings. Okay, the bald eagle, even though the bald eagle is no longer a federally endangered or threatened species, it still is considered as an endangered species in the state of New Jersey.
Mm-hmm. And bald eagles mainly roost and nest in trees, correct?
That's correct.
Yes. How many trees will be cut down for this development?
I don't have that answer.
Okay. Feel free to cut me off if this is not okay to ask, but how did you determine that removing that number of trees, including 88 of which are 13 to 24 inches in diameter, wouldn't impact bald eagles or other important avian species on the site?
Well, first of all, from a bald eagle standpoint, okay, the bald, understand what the bald eagle wants, okay? The bald eagle fishes in the stream, okay? Now, this stream corridor, my personal opinion is I think this stream corridor, if I really want to see a bald eagle in the next 3 days, I wouldn't go to this site to see a bald eagle, okay?
Okay.
The habitat is just it's a good habitat, the stream corridor and everything. The water body itself just isn't big enough to really attract what a bald eagle's fishing for, okay? I mean, in this, yes, I said that there's aquatic ecosystem. I said there's a fishery resource associated with this. I think our fishery resource associated with this is probably, in the lines of, like tessellated darters, shiners, things like that. Way too small to attract a bald eagle, okay? Am I saying that a bald eagle would never land there? Absolutely not. The minute I say that, you take a picture of a bald eagle and it's there, okay? But, and that's why I included it. Another reason is that if a bald eagle was going to utilize any part of this site, if he was going to hang out any part of the site, if he was going to land any part of the site, it'd be in that stream corridor.
No further questions. Thank you for your time.
Hey, thank you.
Yeah, you're good? Okay. We got about 15 minutes, so we'll briefly. Yep, so I may have a motion to open to public.
I'll make that motion.
All in favor?
Aye.
Aye. If there's anyone from the public who's not represented by any of the objectors, you may come up, state your name and address for the record, and focus your questions strictly on this witness's testimony. And we are going to have a hard stop at 10, so, yeah.
David Brook, 7 Winding Way. I'll talk fast.
Don't talk too fast, I have to hear you.
Mr. Cook, as an ecologist, do you hold any professional licenses from the state of New Jersey?
The state of New Jersey does not license ecologists now.
Okay. You and your firm prepared the December 10, 2021 report titled Ecological Resources Inventory and Impact Assessment Report for Homestead Road LLC. Is that correct?
That's correct.
Were you paid for that report?
I was.
Do you recall who paid you for that report?
The applicant.
Could you tell me who the applicant is?
Homestead Road LLC.
So you received a check from Homestead Road LLC?
Objection as to relevancy.
It's extremely relevant.
Objection as to relevancy.
It's extremely relevant. We don't know who the applicant is, and I'd like to get some clarity.
That's not through this witness.
Knowing
It's
who
not through
paid
this witness.
him can help us understand that.
I'm instructing him not to answer the question. It's wholly irrelevant and
He already
inappropriate.
answered. If you're looking for principles, you're probably going to have to do some research outside of this.
So is it safe to conclude your 2021 report never mentioned the drainage ditch in question on the eastern side of the overall property?
That's correct, because I was included in the area that I consider as developed, maintained.
You indicated in your testimony that you were aware of the letter of interpretation submitted to the DEP. Is that correct?
That's correct.
You also stated that Van Cleef Engineering conducted submitted the LOI. Is that correct?
That's correct.
Okay. And that Van Cleef Engineering in the LOI did not note the ditch as a wetland in their application. Is that also correct?
That's correct.
Okay. You and your firm, Mr. Cook, prepared the February 20, I believe that's the date, 2024 report, now titled Ecological Resources Inventory and Impact Assessment Report, Supplement Report for Homestead Road LLC. Is that correct?
That's correct.
Were you paid for that report?
Objection.
Probably not. I probably didn't bill for it yet.
So let me ask the question differently. Have you billed it for it yet?
Objection. It's wholly irrelevant.
It's highly irrelevant. It's highly
It
relevant.
might be relevant to you. It's not relevant to the planning board in this application.
Fine.
You authored the report.
I authored the report, yes.
That's all I need to know.
For the wetlands review, right, you indicated that you visited the site in October 2022, November 2022, and March 23. Is that correct?
That's when I accompanied the DEP, yes.
Okay. Was there anyone else who attended those visits with DEP? Besides DEP, I'm sorry.
No.
Just you and DEP?
That's correct.
Do you remember the names of the people from DEP who attended?
Yes, it was Mark Harris, attendant 1, Mark Harris, and I believe Mark Davis, the section chief, attended another, and Mark Harris was another.
Okay. Did you generate or prepare any notes of the DEP visits?
No. Well, let me backtrack. What I did note is what revisions to the wetland line were agreed to, so that I could provide them back to the surveyor so they could modify their wetland survey plan.
When you say that, you mean DEP? Or the applicant? I'm sorry.
No, so that the surveyor, the contracted surveyor, could revise the wetland survey map as per the DEP.
Is it possible that we could put up the LOI map for Lot 33? That would be very helpful, I think, to all of us. That's the May 25th one that has the stamp of approval from DEP on it. So you did not prepare any notes. Did you ever produce or send any written communications to DEP as to these visits as it relates to wetlands?
I would have put together a transmittal letter with the revised survey saying attached is the revised survey per DEP's requirement.
That's not in your report, I assume?
No.
Okay. It would be helpful, I think, if you could provide some of that information, because there is a question here with regards to how did this change take place? We identify the fact that Van Cleef did not put it into the LOI.
I'm going to object. He's not even asking a question, and we're not providing anything further. This board does not regulate wetlands. The NJDEP does and issued a wetlands LOI.
I'm not sure what the objection is, but I'm trying to get information as it relates to a relevant matter before the board.
The DEP LOI speaks for itself.
Well, apparently not well enough.
Maybe not for you, but for everyone else it does.
As it relates to the visits that took place with DEP, how did it come about that there was a change in the identification of the relevant wetlands?
During our field inspection with the DEP, where the DEP is reviewing the proposed wetlands limits and proposed wetlands areas, determinations are made in the field by the DEP in my presence that certain areas, in their opinion, did not satisfy jurisdictional wetland criteria, and other areas did.
Okay.
And the areas that did got added, the areas that didn't were removed.
So you indicated on page 6 of your report, New Jersey DEP required various revisions to the proposed wetland limits on the property, correct? Page 6.
That's correct.
Do you have any copies of those communications from DEP?
I did not have a tape recorder with me during our field meetings, no. We walk, we look at criteria, and we agree.
You're saying?
There's no, I mean, we have notes on plans on what DEP wants to see. Beyond that, that's what it is.
Chairman, I'm going to object to this line of questioning. The DEP's issued their LOI. The town even appealed it, and the DEP dismissed it. It's the law of the land as to the wetlands. So if he has an issue, he should have appealed the LOI when it was issued.
Mr. Giannetti knows that third parties can't appeal DEP determinations, and that's not the relevant issue here.
They can request an adjudicatory hearing.
The relevant issue is the jurisdiction. Is this a wetland or not? And that's the question.
The DEP has already answered that in their LOI.
It is considered as a jurisdictional wetland. It's considered as an ordinary resource value jurisdictional wetland. That's why it's referenced.
Okay, so we'll get there. With regards to the changes that you referred, whose responsibility was it to make them? Was it yours?
Objection again. It's irrelevant. The LOI has been issued, the wetlands have been delineated. We can move on, please.
You indicated on page 7 that the ditch feature, page 7 of your supplemental report, that the ditch feature that exists on the northeastern portion on lot 33 was added to the wetlands survey map approved by DEP. Is that correct?
That's correct.
Were you involved with the discussions that allowed for that change or promoted that change, I guess?
Yes, I accompanied DEP on all of their field visits and concurred with them, yes.
And you're indicating that there were no communications, is that correct?
I'll clarify. Are there any written document, or was it all verbal communications?
It's
Oral
verbal communications while 2 or 3 biologists are in the field and writing notes on a plan on how it has to be revised.
Okay. You indicated that the drainage ditch, this drainage ditch that we can now see, if that's possible, maybe we can make it a little bit bigger. It's the vertical line on the drawing, correct?
That's correct.
That this drainage ditch was classified as a wetland by the DEP on the approved wetlands delineation map dated May 25th, 2023. That's your statement, correct?
That's correct.
And did you play any part in that classification of the ditch?
I agreed with the DEP that it should be added as a jurisdictional wetland, and I agreed with the DEP that it should be classified as an ordinary resource value ditch.
Okay, and we'll go back to that word in a minute. So you're familiar with the freshwater wetlands regs that New Jersey's put out, NJAC 7A, 7:7A-3.1, right? That addresses identifying wetlands.
Yes, I am.
Okay. I'm sure you're familiar with also the federal manual for identifying and delineating jurisdictional wetlands. That's the 1989 125-page report.
That's correct.
So ditch in the DEP regulations means a linear topographic depression with beds and banks of human construction which conveys water to or from a site which is surrounded by uplands and which is not located within a wetland. Do you agree with that definition?
That's correct.
Okay. You indicated that 3 factors determine if a location is a freshwater wetland. Right? Those are the 3 things relating to hydrology and soils and vegetation. Is that correct?
That's correct.
Now, you indicated before that there was flowing in this ditch at least one time.
At least one time there was water in the ditch.
So does that indicate hydrology when you see it one time?
That's hydrology at that time. Hydrology is also obvious as evidenced by a channel.
And other than the visits that you took with DEP, what field work did you conduct at this ditch?
Beyond reviewing the overall site and classifying different areas based upon habitat types, I didn't spend a lot of time with this ditch.
Okay, did you take soil samples to determine the natures of the soil?
Where, in the ditch?
In the ditch?
Yes.
Okay. And what did you classify those soils as?
Those soils within the ditch met the criteria for hydric soils.
Do you have any results of those reports in a written format?
I do not.
Did you put those results in your report?
I did not.
Did you prepare a list of the plants by genus and species to identify how many of these plants are hydrophytic? By the way, hydrophytic means plant life adapted to growth and reproduction under periodically saturated root zones. You know that word.
Again, we're still talking about the ditch.
The ditch, right.
Yeah.
Did you prepare a list of plants that would identify that they were hydrophyte plants?
No, it was observed during field inspection.
And did you ever write any of those down or put them in your report?
No, they're not in the report.
Okay. And were there hydrophytic plants in that ditch?
There are some, yes. It's predominantly alien invasive species, but there are a few indications of sensitive fern and sedges in that ditch.
Okay. Can you show the board on the map where the wetlands boundaries are for the identified wetlands? Should we presume that that is in the area near the stream, next to the stream, and identified as wetland with a line?
Well, again, the survey delineates all wetlands, all regulatory wetlands associated with the property, which on this plan here shows the line along the tributary stream, and then the line is added as a wetland line encompassing the ditch, and then continues on the other side.
So that's where I guess I would like to get a better clarification. You're saying it encompasses a ditch. It does not appear to accompany the ditch, right? What is the ditch called? It's called an ordinary resource value ditch. Is that correct?
That's correct.
Okay. And there are wetland boundaries that are called buffers. Is that correct for the actual wetlands on the delineation?
The plan shows wetland transition areas adjacent to the wetlands that were classified as intermediate resource value.
Correct, but it's still listed as a ditch. Why is it called a ditch when a ditch cannot be a wetland?
The ditch is a wetland.
Okay. Well, we'll disagree then. Can you show the board on the map how one can find that the DEP, not you, but the DEP has labeled the ordinary resource value ditch a wetland? Where does it say it on the map?
In the wetlands letter of interpretation, it references these points of the ditch as a wetland ditch.
Is that information in your report?
I believe I referenced the fact that we got the wetlands letter of interpretation was issued and that the ditch was added as an additional jurisdictional wetland that the DEP required.
Okay.
I'm going to cut. We're at 10 o'clock.
Chairman, if you may, if we could just finish this witness. The hearing didn't start till 7:15. If we can have those 15 minutes, or at least whatever time is left to finish this cross-examination from Mr. Cook.
Three questions.
I mean, if you're
no
saying he's
multiple
done
parts.
also, then I'm fine.
Then you're fine. but we have some overtime to consider here too.
Okay.
So costs. So all right, but there are three questions, one part each. We're not okay. I've seen back to school.
10 minutes. 3 minutes. Mr. Cook, you indicated that Mr. Shockley told you he dug this ditch. That's correct?
That's correct.
What proof do you have to that information?
None, just him telling me.
Right. So it's basically somebody telling you, but there's no record, there's no information to confirm anything that you were told.
I have none.
Okay. So you have no proof of those conclusions, do you?
Objection as a clarification. You're talking about the spoken words. He's testified already as to other reasons why it's clear to him it's a man-made ditch.
No, I'm just
But you're
talking about
referring
Mr.
to the
Shockley.
spoken words.
I'm just talking about Mr. Shockley. You have no proof of that conclusion that he presented to you, do you?
But again, I
think
object to the form of the
He
question.
testified that he spoke with Mr. Shockley, and that was his recollection of the conversation.
Right. I just wanted to confirm that there's no proof that he has. That's
And again, the DEP classified that as an ordinary resource value ditch.
right. And you also recognize that as far as DEP is concerned, it regulates water features whether they are natural or man-made. Is that correct?
That's correct.
Okay. I have no more questions. Thank you.
Okay.
That's great.
Well done.
Thank you.
Thank you. We are going to continue at the next time they're back here, where we're out of time. Well, we're going to have that discussion now, so. Yes, so, let's try to find a date. I think, do we have to extend time of decision?
Are we anticipating Mr. Cook continuing?
I think so, because I had someone in the back that was waving.
I guess we maybe get a raise of hands.
Okay, I see 2, 3, we got at least 3, 4 members of the public. So, Mr. Cook, we're going to have to look at your calendar too to see when you can come back.
I don't know of anything better that I could be doing on when.
I think it's
Thursday nights.
Is April 11th the next?
April 11th? April 11th, there is another application that would be going first with at least a time allotted of an hour. And that's the Sherman application.
Okay.
And so that would make this application available for after that.
Yep, so for about an hour and a half, I would say.
Hour 15 for this application. We need to get the other applications started before I grow older.
Right.
No, I'm just anticipating the start of the meeting should only take 30 minutes before we get to application, so. Yeah. Are you available April 11th?
Yes, my
Okay.
grandson will be born by then, but
So,
Should be born by now.
that's what
I need to
I'm
verify
looking
with the
at.
objectors.
I had 6 to 8 hours when I
there you
left.
go. And objectors, April 11th works for,
There you go. White glove service.
there you go. All right, so
And
then
I
we
think
also
in-
need to discuss extending time of decision, because right now it's April 1st.
Well, since we're not going to have a full night on the 11th, I believe June 6th is the next full meeting. If we can get scheduled for that time as well, I can extend past June 6th.
We good?
So this happens at every meeting. So bear with me as I'm going to just keep saying the same thing. We have other applications that are going to be in the process of being deemed complete or deemed complete.
Actually, along those lines, maybe we'll, I guess to confirm, there's nothing in May?
There's nothing available at the moment in May. But as we are scheduling things, we're...
Mr. Coyce, can
Yes.
we agree that we can give this applicant a majority of the evening on the 6th?
Well, I think the only thing is we may not have our planner available on the 6th. So
Okay.
maybe on the 11th, we can figure out
Okay.
what the next meeting date's going to be.
Speaking of your planner,
Well, we're going to keep that in mind. What we're trying to do is we're trying to bundle, believe it or not. We're trying to bundle applications together. So
why don't we leave it for at the 11th?
yes, I mean, we're trying to be extremely conscious as we're making those decisions and to try to work with everyone as fairly as possible.
In between now and the 11th, too, I'll let you know as to...
That would be extremely
When we're
helpful.
available as
And we're
well.
also going to check with other applications to make sure that everyone is supposed to be when they're supposed to
Sure.
be. So yes,
Great.
a little bit of a balancing act.
Mr. Chairman, on the planner issue, Ms. Cafone last provided Mr. Giannetti a report to this board on or about August 17th of last year. If you are planning on having her testify as to any items that have occurred subsequent to her August 17th report, but prior to her appearance, we need another updated report, and I would ask it be provided at least 4 weeks in advance of her testimony, so that everybody can deal with it accordingly. And I believe there'll be at least one planner from the objectors that they'll do, so we can sort of continue to move the process. So if you can prep her for more work and more billing. Thank you. I believe there's one other item, but I think Mr. Lanahan wants to speak on the issue before I do.
I want to make this really easy.
Yeah.
My voice come on, rock and roll.
Come on.
Go sit down.
I don't want to hold it.
2.
Yeah, I'm not looking to have a debate or long conversation. Mr. Bernstein's letter from March 5th made a recommendation to the board about providing certain documents. I'm just wondering, I'm asking, is the board going to make that recommendation tonight, or what is the next step with this?
No, the next piece of the puzzle, and that's why I could see you were itching to ask the question, and I will then go from there. We asked Mr. Giannetti to provide certain documents for them, in fact, in my letter. 17 minutes before the meeting started, which I have not looked at because the Wi-Fi service in this place, fill in the blank. Apparently, Miss Curley from Mr. Giannetti's office sent me a love note with an attachment to it that I have not seen. I believe Mr. Giannetti is also working on getting me some of the additional documents that I have requested. He may or may not object, we'll see, as to the promulgation of one of them. Once we get all the documents, or I get the responses I'm going to get, I'm going to advise the objectors accordingly as to what I have.
Fine.
I would then ask you all to respond if you so choose. I'll have all the documents by when, Mr. Giannetti, because I'm trying to work backwards. When? Any more? I know you're giving me more.
So we've provided a certification from Eric Reif that he's the sole member of both Enhanced Acquisitions LLC and Homestead Road LLC. It's no different than the certification. Actually, Homestead Road, they had to certify, he had to give the 10% ownership disclosure, which identified him as the only one. We'll provide a State Department of Division of Taxation record that promotes the same thing. We're not providing a copy of the purchase and sale agreement. I showed you before the meeting, I would say in camera, a copy of the agreement, certain redactions, but showing the assignment provision.
You showed me pieces of 2 pages. Just let's get.
Understood, but that's.
As I said, at the moment, I will address that issue when I get the rest of the documents. I will have everything by
next week.
All right. By a week from tomorrow at the latest?
Sure. Okay. But again, to reiterate our point, we're doing this as a courtesy. We have the owner's consent for this application. And we disagree with the letter and the opinion. The AB Monmouth case you cited is wholly not applicable. That dealt with a condo unit owner, a single condo unit owner trying to do a development application. When he's not the sole owner of the common elements, the whole condo is. So we have the standing and it's on file already. We'll provide this supplement information.
Let's try very hard at this hour to avoid doing what attorneys do so well, which is arguing a point that isn't there. You intend to provide the documents by the 15th?
Yes.
I will give the objectors 2 weeks, or actually just under 2 weeks, but you want to send it to me on Good Friday, that's fine, because not my holiday. I will then endeavor to get an answer by the end of the following week in advance of the April 11th, or by that Monday in advance of the April 11th, and circulate it to Mr. Giannetti, the board, the objectors. I am not putting this on Civic Clerk any more than anything else is going on Civic Clerk until such time as at least been circulated to the objectors and to counsel for the applicant and the board. At that point, I'll cross that bridge with Mr. Coyce. But we will have at least some response to this issue by the next meeting.
Okay.
On that timeline, assuming everybody meets that timeline. Thank you, Mr. Chairman.
No, thank you.
Thank you.
If I may, not to delay the meeting any longer, but I did have a request from Mr. Giannetti and his client. Would it be possible and permissible to have Princeton Hydro come look at the site?
For what purpose?
To look at the ditch, to look at the site.
No, we're not consenting to that. The DEP's already ruled on this issue. We're not reopening for the planning board to decide whether it's a wetland. The answer is no.
Thank you.
Okay.
Mr. Chair.
I think we still need a time of decision extension.
Yes, we need
What do we want
extension
to
of the time of decision rule till when, Mr.
Till when?
Giannetti?
May 1st, 2024.
Thank you.
Okay.
So, Mr. Chairman, this is a motion to continue Homestead Road LLC, file number 21PB25MS/MSPV, to Thursday, April 11th, 2024,
At 7 p.m.
At 7 p.m. or as soon thereafter as the matter may be reached.
Right.
Whatever that will be, without further notice. One last question before the
And a
board
time of
takes it.
decision till
Do
May
any of the
1st.
objectors, well, two parts, do any of the objectors anticipate not being here that night? Come prepared with a possible witness, folks. I don't think we'll get there, but come prepared anyway. I know, that's what I'm saying. Just in case Mr. Giannetti decides Mr. Cook is it and he doesn't need the planner, which is his own problem. But leaving that aside, at
I
least
thought Mr. Cook did a great job tonight, so I made the stress after.
I'm not a planner, okay? I'm not an engineer, I'm not a planner.
Well,
You got that down. You will be a grandfather short.
I'm the Bugs and Bunnies guy.
So the point is that going forward, objectors need to have witnesses either available or potentially available and updated reports as well, so that we don't end up at some point with we're not ready yet.
Okay.
Thank you, Mr. Chairman.
Okay, so a motion, as Mr. Bernstein stated, with regards to the extension or continuation on April 11th with a time of decision now of May 1st, 2024.
I'll make that motion.
Okay, Mr. Scoma made the motion. Is there a second? Okay. Yes, Raj, that's all I'm going to say. Okay, roll call, please.
Mr. Wagner? Yes. Mr. Scobo?
Yes.
Ms. Smith?
Yes.
Mr. Vitale?
Yes.
Mr. Depp? Yes. Committeeman Lapani?
Yes.
Deputy Mayor Chicarelli?
Yes.
Vice Chair Peason?
Yes.
Chair Sirachi?
Yes, just a reminder, we do have a meeting next Thursday, March 14th at 7 p.m. And with that, I'll entertain a motion of adjournment.
Thank you, Chairman.
Thank you.
Second.
All in favor? Aye, we're adjourned.
Come on, guys.